He wants to be an owner, but not have anything to do with the allocation. It's my property. I'm not paying to have my property evaluated.
The owner is Mr. Guerra.
That Mr. Guerra was not made a party. Well, they ignored the due process.
The path that has been chosen by the respondents is to obfuscate discovery. As you can see by today, I still have not gotten the discovery responses.
Next page, page 1, number 1.
This is Rogelio Saucedo Jr. versus Nalia Guerra Ernesto Guerra. Cause number 2016 CVG 1382C3. Court marks Mr. Tamez present in person. Ms. Aldana present by video conference. Rogelio Saucedo is present in person. Ms. Nalia Guerra and Ernesto Guerra are present by video conference. Counsel, what is the announcement?
Yes, Judge, as to the two motions pending before the court today, on the motion.
Well, there are three.
Sorry?
There are three.
I have two.
Motion for enforcement, motion to compel, and appointment of an appraiser.
For
Motion.
we're going to go to mediation. We're going to go to mediation for that.
Well, I don't know what the motion for enforcement means, but I have two: motion to compel and motion to have the court appoint appraiser.
The motion for enforcement of property division and modification of the child support order was filed by.
Well, that's me, but I think that's on the merits. I don't know why that's.
Oh, they're not. Well, no, there's a petition and then there's a separate motion.
Really?
You said on both.
Huh. Okay. Well, I think the motion itself, Judge, is for purpose of the petition on the merits, which that's still pending based on
Sure.
protracted discovery issues that we're having in this case.
Sure.
Before we continue, Your Honor, there is background noise from Ms. Guerra.
Ms. Guerra, we're gonna put you on mute momentarily because we want to make sure we have a. There it is. All right. I apologize. Go ahead.
No, Your Honor. My apologies if that, for some reason, that was confusing on my part. I'm not sure what that motion was, but on the motion to compel, Judge, this was a discovery that was propounded on Mr. Guerra, and we never received any responses. Counsel has agreed that the objections have been overruled. Serve discovery responses are within 2 weeks. The motion to appoint the appraiser, Your Honor, that is based on the report that the Master in Chancery, Mr. Sigifredo Perez, filed with the court. And so for purposes of effectuating that report from the Master in Chancery, the parties have agreed that they will name Paul Porras to conduct an appraisal of the property at issue, that being the apartment. And then we can file an advisory with the court with that appraisal. I don't think we discussed this with Ms. Aldana, but I would propose that Mr. Porras's cost be divided equally amongst the three parties, 1/3 each.
Ms. Aldana?
I am requesting that if it's going to be divided, that at the very least it be Mr. Saucedo and Ms. Guerra 50-50.
And the only reason I say that is because, as we heard prior, Mr. Guerra continues to say that he owns the property. So I think it's only fair that the parties split that 1/3 each. We've got a person claiming legal title and two people that have claimed equitable title pursuant to the court's decree. So I say we split it 1/3 each.
Yikes! What a difficult call you all set up for the courts. So on the one hand, because normally what I would say is everybody get 50-50. You have two sides. Ms. Aldana says special appearance. This person isn't here. He owns it but shouldn't pay, and that seems like an inconsistency. Well, I've overruled the special appearance. If there is an agreement, let me think about this. If there is an agreement that the thing be appraised is the true, right, and just and equitable thing to do, to be divided half or 1/3, Mr. Tamez argues that he is a proper party and has been served. Ms. Aldana says it's his property, but isn't really here. If it is his property, why wouldn't he be subject to pay equally with everyone unless he isn't an owner and then he had nothing to do with this? You see the inconsistency. I mean, it's like he wants both things. He wants to be an owner, but not have anything to do with the allocation of this court's ruling at the end of the day. I mean, it would have been a lot easier had the reverse been true, had Mr. Tamés said there's two sides 50-50, and Ms. Alania said, no, he's an owner. We disagree with the court's ruling, but he's an owner, so he gets to chime in. But now she's saying he's an owner, but he's absolved of any payment on this. What an interesting situation. I mean, crystallize your arguments, Mr. Tamés. Why should Mr. Guerra pay? And I'm going to ask you the reverse, Ms. Alania. Crystallize this, please, because I see that there's just some logical inconsistencies with saying, you didn't serve me, I'm not really here, it's my property, I'm not paying to have my property evaluated. Give me why should Mr. Guerra pay Mr. Tamés?
Yeah, so as I mentioned before, Judge, the law recognizes title, right? Title ownership is an incidence of ownership. The court and our legal system in Texas also recognizes equitable title. Now, from what I've heard from counsel in representing Mr. Guerra, she's saying, I don't care if the court adjudicated equitable title in Mr. Saucedo and Ms. Neyla Guerra. The owner is Mr. Guerra. Okay. That's going to be litigated. That's going to be determined to what extent. But because of that, the law recognizes bare legal title and equitable ownership. In this case, I'm assuming we have three parties. We have one plaintiff, two defendants. They're all making claims of ownership, equitable ownership as to Mr. Saucedo, equitable ownership as to Ms. Guerra, and bare legal title for Mr. Guerra. So I think equally all three should be burdened with this cost because that's the argument they're making.
Response: why should Mr. Guerra not take a 1/3 of this bill, Ms. Alania?
This is an enforcement of a divorce decree, a divorce between husband and wife. They're the ones that Mr. Saucedo is seeking some remedy from Ms. Neyla Guerra. As far as any arguments about title, that should have been done in 2017. And therefore, our position remains that Mr. Guerra was not made a party. And therefore, to say we have equitable title just because we said so is inappropriate because the true record owner was never brought in. And now, not only was he denied due process back then, now he's being told, in addition to that, now you have to pay 1/3 of this appraisal. It's unjust.
Let me ask you this. Let me ask you both this, and I don't know the answer. And the answer to these questions is going to resolve this issue. Although it's a 1/3, I can't imagine that this is. I don't think anybody should be losing sleep over this. But I do want to get it right in any event. So, what in the record, Mr. Tamés? And I'm going to ask you the same question, right? Maybe I'll start in reverse this time, Ms. Alania, and then I'm going to ask you, Mr. Tamés. Ms. Alania, what in the record reflects that Mr. Guerra is an owner, whether in title or in equity or anything else? Because what the court presumes at this juncture is that the only finding is in the final decree of divorce, May of 2017, that says there's two owners. So just on that, just at that one time one, there's two people, there should be two split 50-50. But I think your client, Mr. Guerra, is now making the argument that he's some sort of owner. If that's true, then he should partake in this fee. So tell the court what in the court's record, in the case file, evidence shows and proves that Mr. Guerra is a title owner, either in fact, in equity, or anything else.
The final divorce decree orders him to sign a special warranty deed because they recognized that he is the title owner. Again and again, we have filed a deed showing that he is the title owner. Again and again, we filed pleadings showing that he is the title owner and that he was never given due process to defend his title.
Same question, Mr. Tamés?
Yes, Judge. I think what counsel misses is that there's two types of ownership. And bare legal title does not mean that my client or the court could not adjudicate that they have equitable title. I understand this argument. I think that's been discussed ad nauseum. The gentleman is before the court. the gentleman is here, and I assume the gentleman is continue to argue that it's his property. So if the gentleman is going to continue to make that argument, that I think the gentleman needs to be proportionally charged with the expenses of defending this bare legal title that he's claiming. I think that's equitable. If not, then that's fine. We'll split it 50-50, but I think that will cut against this argument because you can't have that duality. You can't make at one time an argument that I am the owner at the same time saying, but I'm not going to take any responsibility and pay no expenses as a true owner. So it's inconsistent and it's, we can't have it both ways. But, you're right, Judge. At the end of the day, I think Mr. Porras charges $750. It's not going to break anybody's bank. We'll live with whatever order the court decides. But this is just another example of how we're having these inconsistent claims being brought before the court. And I'll stop there.
It's never been inconsistent. I've always advised the court that Mr. Guerra was never given due process. I've never been inconsistent about that.
The inconsistency is in the failure to recognize title, bare legal title, and equitable title. As the law is recognized in the state of Texas and has long been recognized in the state of Texas, that exists. Ignoring it does not make her position correct.
Well, they ignored the due process. They ignored joining Mr. Guerra as a party to defend his title record to people who are claiming equitable title. He was supposed to be joined, and he wasn't.
It's the language that I'm mulling over. So under Petitioner 7, the portion of the decree that awards the House, both parties affirm, and they acknowledge on page 31, they acknowledge that they've had time to review, they acknowledge receipt of the decree, they acknowledge they were represented. So everybody knew what they were getting into, and nobody can take that back. Not Mr. Saucedo, not Ms. Guerra. But then on Petitioner 7, the line item that designates the House, it clearly says that these two parties own a 1/2 interest. Doesn't mention anybody else. Now, that has to be tempered with the portion on page 30 that says, but there's going to be a special warranty deed between the parties. And then on page 29, it does. Now I see Ms. Aldana's point. On page 29, it mentions Mr. Ernesto Guerra. So what's clear to the court is that the parties, and in this case particularly, Ms. Guerra, contemplated this and entered into this agreement being fully advised, but haven't been given an opportunity to read, review, and object to if it was an incorrect decision. But there is also nothing in the record that allows the court to crack that egg open. In other words, I can't undo that. I see the inconsistency, but there is nothing in the record that allows this court to go out and change that. So this is the result. The only two parties that were party to that decree are Mr. Saucedo and Ms. Guerra. So the cost is split 1/2 each, but it's clear to me that Mr. Guerra has a claim against Ms. Guerra for that representation. Whether it was truthful or not, that's where it stands.
I'm curious, why isn't Mr. Saucedo involved if he made that same allegation? Why is it only Ms. Guerra that's being pointed out?
I would answer that question by the fact that they're sitting right next to each other, Judge. It's father and daughter. I mean,
That is not sufficient.
If the question, Ms. Saldana, is whether each party had a legal duty to disclose, I think the answer is yes. I think Mr. Saucedo had a legal duty and Ms. Guerra had a legal duty. If the question is who had the moral obligation to advise the parent that they were being brought into the suit in this manner, I think the answer is clear too. But as a matter of law, I think you're right, Ms. Saldana. As a matter of law, you are right.
As a matter of law, it is a void order to order him to sign.
All right, already ruled. Those are the orders of the court. We will see you here. You said that there was an agreement to mediate. Did the court hear that?
I think that's not accurate at all. We had an agreement to mediate back in January. And the agreement that I had with Ms. Saldana was you produce the documents that I'm sending you in discovery because I need that information to make a fully apprised and acknowledged recommendation to my client at mediation. The path that has been chosen by the respondents is to obfuscate discovery, as you can see by today, and as you can see by the fact that I had to file a motion for contempt with a show cause order.
So knowing all of this, knowing that there's now an agreement as to the responses, and now the appraisal, and now the court even sided with Ms. Alania as to the disposition, the payment, and division of that bill. How much time would be reasonable? And I think, are you going back to the master or not?
I don't think so, Your Honor, unless if we need to take depositions to further discover some items, we
All
can
right.
possibly do that. But for now, I think it's getting the appraisal. I have a motion to for contempt
Knowing the, but I thought there was an agreement on that,
on the what?
on the motion for contempt.
No, that's just on the motion to compel. Separately, I just filed last night a motion for contempt with the show cause order on Ms. Neila Guerra, because aside from the fact that we already had to file a motion to compel discovery responsible for her, I still have not gotten the discovery responses. And so I was forced to file a motion for contempt on Ms. Neila Guerra. Today was just a motion to compel Mr. Guerra.
Well, so knowing all of these things, Ms. Alenia, knowing that there's an agreement as to the responses and no objections, the objections being waived and the 2 weeks, and now Mr. Porras is coming in to do the appraisal, what type of scheduling order, how much time would be reasonable and necessary to schedule, I guess, the contempt, which ostensibly could be moved if this thing is resolved, and then a final hearing, Ms. Alenia?
I would ask for 45 to 60 days because I did give Mr. Tamez all the documents that Ms. Guerra was able to give to me. He's asking for more detailed information. So in order to be able to go back through the years to try to get that, then we're going to need some more time.
Ms. Alenia says 45 to 60 days is reasonable and necessary. Response, Mr. Tamez?
For a trial on merits, 60 would be the minimum based on the way this thing is being discovered and litigated.
A minimum. So there is no objection to that. Now, regarding scheduling, if you're asking for a final setting in 60 days, and that was the max that Ms. Alania was asking for, are you asking for a separate setting on the show cause?
Yes,
How much time would be reasonable and necessary for that hearing?
just to, how much, as far as
2 weeks, 4 weeks, 6 weeks?
minimum a week, Judge, 2 weeks, so I can get Ms. Neila Guerra served with precept.
So,
If
and
her responses are due in 2 weeks, does what procedurally or factually would one have to come before the other?
No, so the responses that we've agreed to serve in 2 weeks is the ones on the discovery on Mr. Guerra. The motion for contempt is on Ms. Neila Guerra. And I have plenty of reasons why in that motion to contempt that it's not just as easy as saying, oh, she gave me everything she has. But a lot of time has been spent on this, Judge, unnecessarily. But this is the path that the respondents have chosen. And so I
Mr. Tamez says 2 weeks on the show cause. Your response, Ms. Alania?
I agree. The order with the real property is void. So yes, a lot of time has been spent on this.
I've ruled, and I appreciate the argument. I think it was a good argument. I've already ruled. I understand, Ms. Alania. I understand your position. It just doesn't help to hear the same argument when I've already ruled. And my question is, for Mr. Tamez's request, unless you tell me that 2 weeks is not reasonable, I'm going to set that. Please answer that question.
I was asking for 45 to 60 days for Nyla's contempt so that we can try to get the information that he's asking for, because he's asking for years from before.
That's the answer that I needed.
That was what
to
I was
hear.
asking.
All right. We'll come back on the show cause on May 19th.
I'm out of town that day. I have a vacation. This time I do know that I have a vacation letter.
Yes, it starts on the 18th. It's been calendared. Come back on May the 5th at 1:30. Any objection, Ms. Alania?
Yes, Your Honor, that is not sufficient time to get all of the information.
Your Honor, if I could just, so the discovery responses were due back in January. So I don't know how much more time counsel needs after I've already filed a motion to compel, had to come to court, get an agreed order, and I still don't have the responsive documents. And we're now in April. So conceivably, Ms. Neila Guerra has had 6 months, half a year to compile the documents that have been requested, which are in her possession, custody, or control, and answer each one of those interrogatories fully. I just don't know why it would take that much time, Judge. Under the rules give us 30 days.
Whatever is in her possession, custody, and control is what she handed over to Mr. Thomas's client. So she didn't do anything wrong. She didn't hide anything. She gave what was in her possession, custody, and control. If he wants more, then we're asking for time so we can try to get more. Maybe I would like to confer with him and see exactly what he's asking for, because I gave him what she gave me,
All
what she,
right. We'll come back on the show cause order on May the 5th at 1:30. We'll come back for final hearing on June the 18th at 9 a.m. Anything else on this case, Mr. Tames?
No, Your Honor.
Ms. Alanya?
no, Your Honor.
Do you have any questions for the court, Mr. Salcedo? Court has heard no. Ms. Guerra, do you have any questions for the court? Court has seen no. Mr. Guerra, do you have any questions for the court? I didn't hear that. Can you? Yes.
No.
Thank you, Mr. Guerra. Ms. Alanya?
Yes, Your Honor. June 18th at 2 p.m.
Excuse me, June the 18th at 9 a.m.
9. Thank you.
Mr. Salcedo, Ms. Guerra, a lot of moving parts, a lot of first-time issues that haven't been contemplated, certainly not in this specific type of scenario. So keep in contact with your lawyers. They're going to continue providing you some good legal advice and preparing you for your hearings. Mr. Salcedo, Ms. Guerra, and Mr. Guerra, I wish you all very well. Have a good day.
Thank you, Your Honor.
Thank you.
Any other cases for Mr. Tames or Ms. Alanya?
That is all for both attorneys.
It's good to see you both. Have a good day.